Family name Waslin. I'm here today by special appearance solely to address discovery and clarify matters from the previous hearing. I am not submitting to the court's jurisdiction for any other purpose and preserving all objections related to jurisdiction. At my last appearance, I was under the impression that there would be no plea entered and the papers would reflect that, as well as me maintaining my innocence, including my constitutional right to assert my innocence. I want to reaffirm that I am maintaining my innocence.
If you want to make a statement on the record here, because we are on the record in court, you have to speak into the microphone so that it can capture your words.
Is this on the calendar? I guess I'm just confused as to what it is.
I want to get to that.
Where's the microphone?
It's sitting at council table right there.
Okay. Do you want me to sit or?
Yes.
Okay.
Let's start again. What is your name, sir?
My name's Colton James, family name of Waslin.
Waslin. Colton Waslin. Cause number 5A0561-562 and cause number 5A0561-563. Mr. Waslin, I see that we're here for a pretrial hearing. Let me hear from the city first.
I do not believe that Mr. Waslin has gotten an attorney yet, and don't know if he wants one. I believe he mentioned at the last hearing that he wished to proceed pro se, but that's not really something in the control of the city.
Okay. So first things first, Mr. Waslin, you need to be represented by legal counsel, or you need to represent yourself. Would you like to apply for a public defender, or would you like to hire an attorney of your own?
I wish to be here at present as myself.
I can see that you're here at present as yourself. What I'm asking you is whether you would like to be appointed a public defender, or whether you would like to hire an attorney of your own.
I wish to do neither.
Well, so, Mr. Waslin, you're not allowed to appear without counsel unless you are asking the court to approve that you be allowed to represent yourself in pro se.
I thought.
Buckle up, because what you're about to witness is peak sovereign citizen energy. 3 men, 3 different stages of denial, and one courtroom system that absolutely refuses to entertain their fantasy land logic. In this first case, we're looking at a classic, a defendant who shows up by special appearance, which is sovereign citizen code for, I Googled some stuff and now I think I'm a legal wizard right from the start. You'll notice a theme. He refuses to acknowledge jurisdiction, refuses to accept legal terminology, and refuses to answer the court's basic questions. Instead, he breaks out the good OL sovereign script, talking about his family name, objecting to the court's jurisdiction, and claiming rights nobody actually has. And here's where it gets fun. The judge is patient. Asterisk extremely asterisk patient. But even that patience has limits. The legal world has very clear rules about self-representation.
Frankly, is a good idea.
The continuance was only due to the fact of you saying that I wasn't able to represent myself or act, for myself, defending myself. If I am able to, then I would like to continue and we can go. But if not, then a continuance would be in order so that I can revisit a few things.
So, to take the first issue first, Mr. Waslin, you are not constitutionally guaranteed the right to represent yourself in court. You are constitutionally guaranteed the right to have an attorney represent you. If you wish to represent yourself in court, the court may engage in what is known as a colloquy with you at a later time, that is to say, not today, in order to see if you are qualified to competently represent yourself. That's something that can take place at a later date. The court will hear your motion to be qualified as a pro se defendant. I also heard that you are asking the court to continue these cases so that you can have time, presumably, to prepare for that colloquy, if that's what you want. I'm prepared to grant it. I will tell you, though, that I cannot grant it if you do not wish to waive your speedy trial right, because your trial is currently set. Pardon me, it's not set. But we have speedy running when?
From the 28th of August.
That would take us sometime into next month.
Mm-hmm.
How much time are you asking for as a continuance, Mr. Waslin?
Well, honestly, I only came here by special appearance to assert innocence and request discovery. But given the matters that
Your not guilty pleas have already been entered at your last court appearance.
which I didn't want to plea or contract with the state or city of Bellingham, which was the issue at hand. I just wanted to maintain my constitutional right of innocence.
Here we go with the classic opening move. The family name declaration paired with a special appearance. For anyone unfamiliar, this is sovereign citizen bingo card item number 1. They believe that by saying special appearance, they avoid entering into the court's jurisdiction, like the judge is a vampire and they're refusing to invite them into the house. But notice the contradiction. He's physically present in the courtroom, speaking to the judge, acknowledging the case numbers, and addressing matters from previous hearings, yet insists he's not submitted to the court. Sovereign citizens try to have it both ways, participating in the legal process while pretending to stand outside of it. This opening also tells us something important about his strategy. He thinks terminology.
We can go before if you want.
I don't have any position in the matter, Mr. Waslin. You're appearing before this court.
I'm fine with that.
And
You're
Your
fine
Honor,
with what?
With
Perhaps-
going before.
perhaps what might make sense is if we just set it over without a speedy waiver, do a very short set until the presiding judge is back and can go through the colloquy, perhaps a week or two.
Certainly, I'll say that, Mr. Waslin. We can continue your matter inside of the time remaining for the speedy trial requirement.
Okay.
But it will be a very short amount of time to prepare for trial if that is what you wish to do without waiving speed.
That is fine, as long as I am able to pick up my discovery today at the end of court. That'd be totally fine with me, because they have not done their obligation of submitting it to me by CR R 4.7.
So, Mr. Waslin, as I understand it, you do not have counsel appointed or having made a notice of appearance in this case.
I'm notice of a special appearance, yes.
And you
Your
have not.
Honor, the city will follow the rules for discovery for criminal procedure. Soon as we get a request for discovery, we will comply with it within the time frames that we're required to.
Thank you, counsel.
Your Honor, what I understand the preference, but CR 4.7 allows I am preserving my rights while requesting.
This is one of those subtle moments where you can feel the judge mentally resetting herself. When she says, "Let's start again," that's judge speak for, "All right, let's try this one more time before I lose my patience." What's interesting is that the judge is giving him every possible opportunity to provide simple, basic information. His name, his presence, acknowledgement of proceedings. But sovereign citizens often treat even neutral questions like traps. They think saying their legal name submits them to maritime law or some other imaginary jurisdiction. Oh, you'll notice he keeps toggling between his actual name and the family name.
You are to update any address changes with the court and with Department of Licensing. You are to only use your true legal name and date of birth to identify yourself to the court, and you are not to drive without a valid license or proof of liability insurance. I have noted on this order that the defendant has requested a continuance. He has noted that he does not wish to waive speedy trial, and he has requested to represent himself in pro se. Arraignment having already been accomplished here, not guilty pleas entered and probable cause found, I don't think that there's anything further.
Just promise to appear. He just needs to sign a promise to appear.
Okay. Mr. Waslin, the promise to appear is before you.
This is where the courtroom dynamic becomes crystal clear. Everyone except the defendant understands the situation. The prosecutor is calm, the judge is focused, and they're both working through standard procedure. Meanwhile, our sovereign citizen is still orbiting in a parallel legal universe. The moment the prosecutor says he doesn't know if the defendant wants an attorney, it's a huge red flag for the court. Judges need clarity on this because the right to counsel is foundational. If a defendant weighs it incorrectly, any conviction can get overturned on appeal. So the judge is being extra careful here. But notice the prosecutor's tone. He's already aware that this guy tried to proceed pro se before and it didn't go smoothly. That's why the city stays out of the way. They don't want to trigger an appeal issue, and they definitely don't want to babysit someone who insists on representing himself.
I'm going to appoint a lawyer to represent you.
I represent myself, ma'am.
Okay.
It's a right. So
Yeah, sure.
I represent myself. Yeah.
Thank you. I don't need you to advise me of the law, sir. But if you'd like to exercise your Sixth Amendment right to represent yourself, you may. Let me hear the people's bond argument, and then if you'd like to make an argument, you may. I'm going to mute you while they do that. Thank you. Ms. Mayfield, what is your argument regarding bond?
Your Honor, I don't think I have an argument under 164113.
So I'm not sure if you do you know what happened yesterday?
Maybe not.
So yesterday, Mr. Mula appeared in Division 7 and was extraordinarily disruptive, using very foul and offensive language, very obstructionist behavior in the courtroom, failing to adhere to court orders, to appear at the lectern, essentially failing to adequately identify himself. What I'm going to do is allow you to make any argument you'd like to make, Mr. Mula, and then I'll make a ruling regarding bond.
Yes, ma'am. I was illegally detained on a bench warrant that was issued while I was in a courtroom for a non-appearance. So, yes, I got irritated. I know my rights, ma'am, and I have the right to travel in regards to the first trespass charge. So, also, I work with the homeless community here.
Okay.
I work with all the programs.
Okay. If you could wait just a sec, what I'm going to do is ask you questions under the statute. I'm going to ask you questions under each subsection. Don't talk about the allegations.
Here we get to one of the most important misunderstandings sovereign citizens have. They think the Constitution gives them an absolute, untouchable right to represent themselves. But the judge breaks it down perfectly. Yes, you can represent yourself, but only if the court determines you are competent to do so. And competence doesn't mean intelligence. It means you understand the law, the process, the risks, and the consequences. The court has a duty to ensure a fair proceeding.
I've been here for 2 years, seeking sanctuary, and I've been bullied and targeted and harassed by cops and other organizations since I've been here for helping the homeless.
Okay. And just wait. Ms. Mayfield, you said you don't know of any record you can make under E or F.
I do not.
Okay. All right. Mr. Mula, was there anything else that you wish for me to know before I address your bond?
Nope.
All right. Okay. What the court is going to do is authorize a $1,000 co-signed personal recognizance bond, no contact with the victim, pretrial supervision.
And who is the victim?
Let me take a look.
And what are the charges? I didn't hear any charges. So.
Yep. So let me tell you, you were, I think, issued a summons, but let me take a look. Yes, you were. And so when you were issued the summons, the
I don't have an
oh,
address.
just a sec.
I live in a car.
Somebody likely handed it to you, but let me take a look. And how about we do this? I don't interrupt you and you don't interrupt me.
Sure.
All right.
Thank you.
You're welcome. Yep, it looks like the officer tried to hand you the summons, but you refused it. So let me share with you what.
Proceeding. And letting someone self-destruct with pseudo-legal arguments actually violates that fairness. That's fascinating is that the judge pulls out real Supreme Court cases, *, Indiana v. Edwards, all absolutely relevant. She's educating him in real time, and he still tries to argue constitutional theory like he's